My name is Pamela Valencia, and I'm a tax attorney at the Riverside Law Office of Dennis M. Sandoval. I have a master's at law degree in taxation, and I'm a certified estate planning, trust, and probate law specialist under the California Bar Board of Legal Specialization. I'm going to talk about tax controversies with federal or state agencies. Here in California, that means a tax dispute with the Internal Revenue Service, or California agencies known as the Franchise Tax Board concerning income taxes, the Employment Development Department concerning employment taxes, or the Board of Equalization concerning sales taxes. I'll speak in generalities and ask you to understand that there are exceptions to every rule. There are three basic reasons that someone calls our office when they have a dispute with the tax agency. The taxpayer thinks, 1, the tax agency got the tax wrong, in other words, there should have been no tax, or the amount of tax calculated by the agency was incorrect, or 2, the tax itself is owed, but the taxpayer disputes the penalty assessed by the tax agency, or 3, the tax is owed and perhaps the penalty is indefensible, but the taxpayer cannot pay the tax. I'll start with the third reason because it's the most common one. If the taxpayer agrees the tax is due, but cannot pay it, two new questions arise. 1, can the taxpayer pay over time if given an installment plan? Or 2, does the taxpayer think he or she will never be able to pay the tax and penalties and interest due? If the taxpayer agrees that the tax is owed, I often recommend that he or she go to the website of the taxing agency. For the IRS, that would be www.irs.gov, and see there whether an installment plan would work for them. It isn't always a good fit because some taxpayers don't have enough net income to make an installment payment that will ever retire the principal amount due within the time constraints set by the plan. The longest plans accepted by the IRS are supposed to be paid off in 72 months, which is 6 years. There are plans that go longer, but they're an exception. If the taxpayer thinks, I owe the tax, but I'll never be able to pay it off under an installment plan, then perhaps an offer in compromise would be appropriate. An offer in compromise is the wonderfully exaggerated scenario you've seen in TV commercials where people brag that they owed the government $1 million and they paid $3.75 and they're now debt-free. The truth of offers in compromise is much more complicated than the advertisements suggest. In evaluating a taxpayer for an offer in compromise, the IRS or the California agency conducts a financial analysis by reviewing the taxpayer's assets, income, and what are called allowable expenses. Each one of those terms needs to be thought through and understood clearly when you're contemplating making an offer in compromise. The IRS uses those figures, the assets, income, and allowable expenses, to come up with what it calls the reasonable collection potential for the taxpayer. If the IRS believes that it can collect the full amount of the debt in a reasonable time from the taxpayer, the IRS will not settle for an offer in compromise. It will go after the full amount. So if the taxpayer does not dispute the tax, but doesn't think he or she can pay the tax in a lump sum, or thinks he or she can't pay the full amount in any reasonable time period, an installment plan or an offer in compromise needs to be researched in regard to the particular financial situation of the taxpayer. Of course, under some circumstances, the taxpayer may want to consider filing for bankruptcy, but that's not something I'll address. Remember I mentioned that there are 3 reasons a taxpayer might contact a tax attorney about a tax bill. I've just covered the most common reason. The tax is not disputed, the penalty is not disputed, but the taxpayer cannot come up with the amount due. The second reason you might call a tax attorney regarding a tax bill is that the tax is due, but you believe that you should not be assessed a penalty concerning the tax. Penalties are assessed for various reasons by the IRS or state taxing agencies. Common penalties are for failure to timely file your return, failure to timely pay your tax, and for understating the amount of tax that you owe on your return. These penalties are sometimes withdrawn or abated by the agency if you can show that you had reasonable cause for your failure or for your mistake. Reasonable cause is something that you might be able to convince the IRS or state agency of yourself. Maybe you had a medical emergency and you were unable to file your return for several months. Perhaps your business burned to the ground and you had to reconstruct your files in order to calculate your tax liability. An attorney might be helpful in crafting your letter to the tax agency, explaining the circumstances and perhaps even citing to other cases where a taxpayer has been relieved of penalties in similar circumstances. Be aware that interest is not abated in the circumstances we've covered unless the tax or penalty that triggered the interest is abated. So if you're assessed $20,000 in taxes and $4,000 in penalty, you will incur interest on the $24,000 until the full amount is paid. If the penalty is abated, interest on the $4,000 will also abate, but interest on the original $20,000 tax will remain due and payable. Penalties are assessed for various reasons by the IRS or state taxing agencies. Common penalties are for failure to timely file your return, failure to timely pay your tax, and for understating the amount of tax that you owe on your return. These penalties are sometimes withdrawn or abated by the agency if you can show that you had reasonable cause for your failure or for your mistake. Reasonable cause is something that you might be able to convince the IRS or state agency of yourself. Maybe you had a medical emergency and you were unable to file your return for several months. Or perhaps your business burned to the ground and you had to reconstruct your files in order to calculate your tax liability. An attorney might be helpful in crafting your letter to the tax agency, explaining the circumstances and perhaps even citing to other cases where a taxpayer has been relieved of penalties in similar circumstances. Be aware that interest is not abated in the circumstances we've covered unless the tax or penalty that triggered the interest is abated. So if you're assessed $20,000 in taxes and $4,000 in penalty, you will incur interest on the $24,000. If the penalty is abated, interest on $4,000 will also abate, but interest on the original $20,000 tax will remain due and payable. Now we've discussed coming in to see a tax attorney concerning an inability to pay a tax or to dispute the assessment of a tax penalty. The scenario that would most likely benefit from the use of a tax attorney is the first one that I mentioned. You think that the tax agency got it wrong, and you either don't owe tax on the transactions, or you believe the agency miscalculated the amount of tax due. In that situation, there are some common sense things that you can do to help yourself and to help any attorney help you. First, write a timeline of events related to the tax event. For example, suppose you think the IRS or Franchise Tax Board agent was irresponsible and somehow delayed your tax bill, and that caused excessive interest to accrue. It would be helpful if you were able to state who you talked to and what the tax agent said each time there was a meeting or a phone conference. Were there threats? Were there promises? And keep other records of your contacts. For example, if you mail materials to agents, mail them certified return receipt requested so you can show when you mailed the documents and who signed for them. And you want to bring copies of all the correspondence that you have received from the tax agency with you when you come in to see an attorney, so that we can determine where you are in the administrative process of the agency. Of course, your correspondence to the agents and whatever tax returns are in dispute will be a necessary part of any efforts by an attorney to help you determine your next steps. This is a very brief description of the most common steps to be taken when discussing a tax dispute. I hope it helps you determine whether you want to seek help in handling tax issues that arise in your personal or business activities. If you need help getting your tax matter resolved, you need to speak with us. Call 951-787-7711 if you would like to schedule a free 1-hour consultation at our Riverside law office to discuss your situation with one of our tax lawyers, or visit our website at www.fight-the-taxman.com to learn about our services.